on the application of ZK Zimbabwe and the Secretary of State of the Home Department.
I think we're not used to having such a small number in this court. Perhaps I could mention that the temperature control in this courtroom is a little erratic. If counsel feel that they're getting too hot, do please let us know. We may be able to make some adjustments to dress, if not to the temperature. Yes, Mr. Hussain.
Appear for the intervener bail for immigration detainees. My Lords, there is one preliminary point concerning anonymity. The appellant does not seek, and I understand has not sought anonymity in these proceedings. So to the extent that his appeal has contributed to the alphabet soup in the court's docket, as my Lord Lord Roger put it in the Ahmed case, that is not of his making. The position is that the Secretary of State applied for anonymity below, and my Lord and my Lady will be aware of the practice direction in Court of Appeal cases providing for a presumption in favour of anonymity. My position is one of neutrality on this issue. I understand Mr. Robin Tam will be addressing you on this point in due course.
So you're neutral.
I'm neutral.
That's helpful. Thank you. I think you've been there before.
My Lord, yes.
Thank you.
My Lords, my Lady, the central question in this appeal is whether a failure by the executive to conduct regular reviews of the exercise of a discretionary power of temporally unlimited detention, where those reviews are required expressly and in peremptory terms by published policy instructions and impliedly required by subordinate legislation, renders continued detention unlawful and gives rise to a claim for damages in the tort of false imprisonment. My Lords, my Lady, we say it does for 9 reasons. Before I outline those reasons, may I make some brief submissions on the facts? My Lords, my Lady, will have seen from the judgments below that the appellant was detained from March 2006 to January 2008, during which time he ought to have had 22 reviews conducted.
Well, more than 22, actually, I thought. I mean, there were the initial reviews until the monthly
My Lord's right.
Cycle, and then there were 22 monthly cycles
Yes.
after the initial group
Yes.
of about 6, I think it was.
Yes, it's 26, it's 4 in the first month, my Lord's absolutely right.
So it's 28 in total, I
Yes.
think I'm right in saying.
Of those, only 10 were conducted, and of those, only 6 were conducted at a sufficiently senior level. But of those 6, 2 were disavowed by the Home Secretary's Council as fatally flawed. One sees that from paragraph 48, page 145 of Appendix 1 of Mr. Justice Munby's judgment. No good reason has ever been given for this serial failure, and before this court, the Home Secretary does not seek to justify or excuse it in any way, I quote, from paragraph 5 of Mr. Tam's printed case. Mr. Justice Munby, at page 146, paragraph 46, referred to the casual mendacity of a system under which written reasons for detention are dated and signed by junior officials before the decisions have in fact been taken. Now, my Lords, my Lady, my client has a conviction for common assault and sexual assault on an adult female for which he received a sentence of 12 months imprisonment. But Mr. Tam, with respect, rightly accepts that the highly unsatisfactory state of affairs in this case cannot be extenuated by the appellant's own character and antecedents. That's his case at paragraph 5. I therefore, my Lords, my Lady, don't need to remind the court that, as Justice Frankfurter said 60 years ago in the Rabinovitz case, that it is a fair summary of history to say that the safeguards of liberty have frequently been forged in controversies involving not very nice people. That was the case of a shabby defrauder, as he put it.
I think that was quoted by Lord Steyn in a rather more recent case, was it not?
My Lady, yes.
I think so.
Is it one of your printed cases? I can't remember.
No, another quotation from Justice Frankfurter
I thought he
finds its
referred
way.
to, but not that one.
Yeah,
No.
that's the quotation about the importance of procedural rights. And it's something quoted by Lord Bingham and Lord Steyn in the Cullen case.
He was referred to yesterday in the House of Lords in the discussion about the Terrorism Temporary Provisions Bill, I think. And I can't remember which quotation it is, but we can check in Hansard to see which it was.
Indeed. In any event, the intervener bid highlights the wider impact of the issue falling for resolution in this appeal. The intervener demonstrates that many vulnerable individuals are detained under immigration detention powers: children, the mentally ill, torture victims. For those individuals, the review of detention is an essential protection given the severe difficulties in securing legal representation to challenge detention, as Lord Justice Brooke recognised in the D case, that's at 982, volume 9, tab 82, paragraph 106, and Mr. McLouth's statement for the intervener at paragraphs 33 to 35 outlines those difficulties. There is, of course, also an absence of any automatic independent review of what may be a protracted deprivation of liberty. So that is the context in outline, and that's all I would like to say about that for now. May I now outline my 9 points, please? First of all, we say that the review is essential to the legality of continued detention because the review is the exercise of the discretion to maintain detention. And that discretion to continue detention must be exercised properly and lawfully.
No, I got all that, Mr. Zane. Do we have to write it down?
I'm going to develop it in due course.
Have you got your 9 points nicely printed out for us?
Well, I'm sorry, I haven't. I'll
Perhaps they could be provided
Indeed.
to us after the adjournment.
indeed, Mark.
Well, if you're dictating them, could you do it at a reasonable speed so that we can write them down if you'd like us to do that?
I'm very sorry. I'll do it again. We say the review is essential to the legality of continued detention because the review is the exercise
Just a little bit.
of the discretion to maintain detention. And that discretion must be exercised properly and lawfully. And we say that it doesn't matter whether the review is seen as the authority for continued detention or as the exercise of the discretion to continue to detain under an initial authority.
This is still for the purpose of your point 1.
Yes.
Doesn't matter whether it's seen as the authority for the detention or
Or the exercise of the discretion to continue to detain under an initial authority.
Well, you say it is the exercise.
Yes.
It is the making of a decision that this person should continue to be detained.
Yes.
It doesn't matter whether it's the first authority or whether it's just a continuation authority.
The key phrase in the statute is may detain under the authority of. And the review can either be seen as the authority for continued detention, or it can be seen as the exercise of discretion may detain, if the authority is a one-off authority that you get at the beginning of your detention. It doesn't matter, we say.
Is this point made with reference to the common law, or is it with reference to Article 5? You haven't got to Article 5 yet, have you?
Common law.
Common law.
My first 8 points are common law points. My 9th point is an Article 5 point. We say, with respect, we have an unanswerable case under Article 5.
Well, are we going to get the 9 points before we start questioning you? Or, because, I mean, if a lot of questions arise.
Indeed. Indeed. So, my lords, that's my first point. The second point is that the Secretary of State accepts that a review can be essential to the legality of continued detention because he positively supports the reasoning in the Roberts case. And we get that from Mr. Tam's case at paragraphs 4b and 18.
Sorry, 4b and?
18, my lord. So at 4b, he says, in some cases, the authorising statute provides that a particular procedural step is a precondition to the legality of the detention. In those cases, a failure to carry out the required step means that the detention is unlawful and entitles the detainee to damages for false imprisonment. That's what he says.
That's Lord Justice Clark's 1999 case.
My lord, yes. And we say that acceptance has important consequences, which will develop in due course. My lords, my lady, my third point is that the Secretary of State is under a public law obligation to follow his policy and thereby conduct regular reviews. And this is common ground. See the Secretary of State's case at paragraph 38. We say that it follows that if he fails to properly do so,
He fails
properly to conduct such reviews, any lawful justification for continued detention is vitiated. Fourthly, we say that in any event, immigration officers are under a statutory duty concomitant with their public law obligation to follow policy instructions issued to them by the Secretary of State. This is the paragraph 1.3, Schedule 2, 1971 Act, point, made by BID in their case at 26 to 27, which we respectfully adopt and will seek to develop.
This is whose case? They're referring to the intervener's case?
The intervener's case,
Yes.
at paragraphs 26 to 27.
Yes. Thank you.
The statutory duty to follow instructions. Fifthly, and this may be important, my lords, my lady, we accept that not all public law errors or policy defaults or even non-compliance with statutory duty concerning actions towards detainees
can do what?
concerning actions towards detainees will render detention unlawful.
Public law error or what?
Or a policy default.
Oh, policy default.
Or even non-compliance with statutory duty.
Yep, yep.
Not all such errors will render detention unlawful so as to give rise to a claim. You may have a duty concerning conditions of detention.
Sorry?
One may have the duty, either in the statute or in the policy, concerning the conditions of detention.
Well, I suppose it might say you've got to supply a toothbrush.
Or the morning paper.
Yes.
You say to give rise to a claim, you're talking there about a claim for damages.
For damages in false imprisonment. Yeah, it's not going to render it unlawful, detention unlawful, and such an error, neither is it going to give rise to a claim of false imprisonment. We don't see any difference between the two. I'm going off my point because the executive is subject to the ordinary law. And it would be heretical with respect for there to be recognised a category of unlawful detention which didn't give rise to a claim.
So is this a kind of de minimis point, or does it go wider than that?
No, the point is that we accept a line has to be drawn somewhere.
Well, no doubt we'll get back to this one.
Yes.
Well, this is the Munjaz type point.
Yes, that's
It's,
what I was thinking.
it's Hague, Munjaz, Cullen.
Yeah.
Conditions of detention, Cullen access to a solicitor deferred under the Northern Ireland emergency legislation, claim for false imprisonment is brought. The minority who are with the plaintiff don't even bother to look at the false imprisonment issue, and the majority dispose of it in one paragraph each. And Mr. Tam places reliance on the case against me. So a line has to be drawn. We say it is not to be drawn, as Mr. Tam seeks to do, and as the Court of Appeal did, around statutory preconditions and substantive public law errors.
When were these? When was this system of review first provided for?
It's been current since at least 1991.
And before that?
Almost 20 years.
Before that?
Well, we don't know because the 91 document was not a public document, and I think it was disclosed in litigation, but not generally available.
Is this the Operations Enforcement Manual?
No, it's something called the Immigration Service Instructions, which dates from 1991. We've got documents from 91, 94, 98, 2001, and the current version, all of which for almost 20 years.
And none of those old cases, the Hardiel Singh line of cases, touched on any suggestion of executive review, did they? I mean, I don't remember them.
My Lord, Hardiel Singh was decided in 1984, and no, it didn't.
Yeah.
So we accept a line has to be drawn, but it isn't to be drawn around statutory preconditions and substantive public law errors. We say that the key question is whether the error is sufficiently closely linked to the decision to detain. And wherever you draw the line, we say we're on the right side of it. Because the review is sufficiently closely linked to the decision to detain. It is the decision to detain. My lords, my lady, my sixth point is that this is a case about an executive first actor who authorises detention, not, like almost all of the cases relied upon by Mr. Tam, a second actor case.
Second actor, then you added the word I missed.
Case.
I said case.
Case.
I don't
So
need,
sorry.
it's,
No,
it's
no, no,
redundant, sorry.
Sorry, okay.
It's not a second actor implementing an order
No.
of a court. In that situation, very different legal and policy considerations arise. There is no public interest in insulating an executive act from legal challenge.
No public interest in?
In insulating an executive act from legal challenge. My seventh point, my lords, my lady, is that we say Mr. Tam is quite wrong with respect to place reliance in his printed case on paragraph 18(4) of Schedule 2 to the 1971 Act. It's quite wrong to say at paragraph 25(c) of his case that once a person has been detained under Immigration Act powers, he is deemed to be in legal custody for all purposes. All that paragraph does is indicate...
It means if he runs away, somebody can catch him.
Exactly. That's all it does. And it covers transport as well. It speaks to the place where the individual is detained. And that's very clear from the leading authorities on the point, which in fact date back to Liversidge and Anderson, where you had an equivalent provision in the emergency defence regulations. And were Mr. Tam correct, you could never have an unlawful detention claim.
You couldn't have a word?
An unlawful detention claim. Hardyall Singh wouldn't run. Eighthly, we will make submissions about the position if causation is relevant. But briefly, we say it's not appropriate to ask the causation question.
To do what? To ask?
To ask the causation question. Namely, what would have happened if a review had been conducted if in fact it was not?
So, I mean, how does it work? Assume you're right on the basic point, and whatever it is, there are 19 months when you are unlawfully detained.
Yes.
I mean, what do you say? You're entitled to damages for all the world as if you should have been at liberty for those 19 months.
Well, that is the principal
No,
position.
no,
Yes.
I'm
That's
not
our primary case, Mark.
That's your contention.
That's our primary case. We make alternative cases, as my lords see. But that's what happened in Roberts. That was the analysis in Roberts. It's the analysis in Christian Luchinsky. Ninthly, we say, we have, with respect to a very strong case, under Article 5, because Article 5.1 requires a deprivation of liberty to be in accordance with a procedure prescribed by law. And it is significant that Mr. Tam does not seek to defend the Court of Appeal's conclusion that neither the Secretary of State's policy nor the detention centre rules were not the law. Sorry, I've got an extra negative there.
Too many knots.
Were the law. Were the law.
Mr. Tam does not, what does it?
Defend the Court of Appeal's conclusion that neither the Secretary of State's policy nor the detention centre rules constituted law for Article 5 purposes. If I can explain, the Court of Appeal concluded that it was main legislation and the Hardy-Singh principles which constituted the law. That, with great respect, was an unprecedented view. No court has ever thought that, but it's looked at the issue. And we, with respect, say it's contrary to principle, and Mr. Tam does not defend it in his printed case.
Which bit of Mr. Tam's argument do we look at for this purpose?
It's 74, my lord. Page, would you like me to?
Well, I'm there. I mean, I'm just...
Yes. So it's, Mr. Tam says the appellant's argument is therefore based purely on the failures to carry out the reviews after the initial lawful decision to detain. What is said that because those failures were contrary to policy and because law includes policy, the detention was not in accordance with procedure prescribed by domestic law. But on analysis, that argument adds nothing to the claim of common law, etc. So he simply sidesteps that.
Well, I just wonder if that... I hadn't read him as disclaiming that approach by the Court of Appeal. I mean, he says if as a matter of domestic law, which, say, above depends on the construction of the statute, I mean, is he...
Well,
I don't know.
I'm sorry, I can perhaps... if I misread Mr. Tam's case, I'm sorry.
No,
Doesn't HL come in here anyway?
Sorry?
Isn't this the HL point?
It is the HL point, my lady. We're a fortiori HL, because in HL there wasn't a sufficient procedure. Here there is a policy. The purpose of the policy is to meet any challenge under Article 5 that the power of detention is too open-ended and too broad, given the context and given the fundamental importance of this requirement. See Lord Bingham in the Gillen case. And therefore we say that it is absolutely and fundamentally law for the purposes of Article 5.
Are you able to direct us to the paragraph in the Court of Appeal where this point is made by Lord Justice Laws with reference to Article 5?
My Lord, yes, it's... paragraph 33 at page 1540, letter G to H. You Lordships have the weekly report.
Yes. And then he comes back to it in his summary, I think, near the end, paragraph
And then
35.
35 too, yes.
35.
35 too.
Thank you.
I think that's why I mentioned HL,
Indeed.
because HL says there has to be something procedural.
Which case, HL?
Yes, this is the Bournemouth case, the mental health case.
There are other cases.
It's not just principle, which is Hardiel Singh. There has to be a procedure for ensuring that the principle is observed.
The point that we make is that the protections which the Strasbourg Court has read into Article 5.1f are redolent of the Hardiel Singh principles. So you've got to exercise due diligence. You can only detain for the prescribed purpose. And you've got to act reasonably. Well, the Strasbourg Court has read those protections in to Article 5.1f.
You mentioned HL in your printed case.
We mention it, and Mr. Porter mentions it in his printed case. We mention it.
Well, I don't want to distract you from your list,
I thought we'd reached the end.
but I think we'd reached the end of it.
We mention it at
Paragraph 114.
114.
Thank
Mr.
you very
Porter
much.
mentions it at paragraph 41.3 in his printed case at page 18. To us, it's 114.
Yes, I see. Thank you. That's right.
Well, that's the 9 points. Do we go back to the beginning and examine them again?
Yes. My Lords, I'd just like to conclude by saying, I'm sorry, of course, under Article 5, if you have a breach, then you're entitled as of right to an enforceable right to compensation under Article 5.5.
Yes.
And our submissions on Article 5 underscore the common law, and their Lordship's House in the Evans case, my Lord Hope will recall, found that to be significant.
And if you're in a 5-5 compensation situation, I mean, same argument, is it, on causation?
No, we accept it's not.
Is it a claim for wrongful imprisonment a tort claim, is it?
We run two claims, a tort claim and a claim under the Human Rights Act.
Yes, but your common law claim is a tort claim.
The common law claim is a tort claim, absolutely, Mother.
For wrongful imprisonment.
For wrongful imprisonment, yes.
And does that start, so to speak, the day the review was meant to be held, and it applies equally if it was the wrong grade of person, if the wrong,
Yes.
is any departure from the stipulated requirements of the review scheme, is that?
You could have de minimis errors, like a signing issue, the form not being signed, but in fact the thing having been
But if it's a
sealed.
day late, you're entitled to a day of wrongful imprisonment without more ado.
Yes.
So take the timetable is described, I think, by Lord Justice Laws. You've got the initial 24-hour review, then you've got the 7 days, 14 days, 21 days, and so on and so forth. Supposing you miss out the 14-day review, there's a breach then of the system for 7 days. Yes. If there is then a review on the 21st day, let us say,
yes, and
the review establishes that he's properly detained,
yes,
nevertheless, there's a claim for the period that was missed?
Yes. And that's supported by authority and principle. The authorities are the Hawkins case, which my Lord Brown may remember.
Which one?
Hawkins. That's the case about, it was a criminal case about whether or not somebody had assaulted a police officer in the execution of his duty. What had happened was the individual had not been given reasons for his arrest at the time of his arrest because he was struggling with the officer. So it was a PACE case, section 28 of PACE. He then calmed down and he should have been given reasons, the court found. At that point he wasn't. And my lords found that prospectively his arrest was lawful. The other authority for the point is the Roberts case again. In Roberts, that is the analysis which Lord Justice Clarke then was favoured.
Well, perhaps you can come back to this. I mean, we don't want to get into too much detail for obvious reasons, but there are various stages through the history, just a few, where reviews did take place and where bail was considered and refused and so on.
Yes.
But you say that in principle, wherever you find a breach in the system, that gives rise to a compensatable claim. Yes,
because of the analysis that the review is essential to the legality of continued detention. We can test it this way. Imagine at the review a decision is taken to release the individual and he's kept in detention. It's simply ignored. The review
the review says he should be released.
Yes. He's not.
And then what happens? Some disobedient retaining officer says, well, I don't agree with that, so he keeps him. Is this the proposition?
Yes, or there's an error.
I see.
There's simply an error.
But I mean, your proposition is that actually you get exactly the same amount of money under your approach, whether, had the review system been followed, he would have been released, or whether he wouldn't have had a cat in heaven's chance.
Yeah, because, as Lord Justice Clarke explained, the wrong is not the failure to conduct the review. The wrong is the unlawful detention consequent upon that. And that's what you compensate for. What you try to do is place the individual back in the position he would have been in, but for the wrong. Restitution is the primary goal of any.
Well, causation is a slippery idea, because, but for the wrong, he would have been reviewed. And on this hypothesis, had he been properly reviewed, he'd have been kept still.
No, but the wrong isn't the failure to conduct the review. The wrong that you're suing in respect of is the unlawful detention. That was Lord Justice Clarke's analysis. On the seniority point, if I just put it this way, the policy, which we'll look at in due course, makes it very clear that only certain individuals of sufficient seniority are allowed to release. So you can have a situation where a junior official says release, but the senior official says no. Now, the submission that my Lord, the question my Lord put to me, that do you get compensation if you don't have the review at the right level, is simply the flip side of that.
Mr. Hussain, I think you can judge that every time you enunciate a proposition, it gives rise to questions. Would it be tidy to go back to the beginning of the list now, and we'll explore each of these a little more fully? Because, at the moment we're getting into the detail on a particular proposition. But
I think I'm being indisciplined.
No, I'm not criticising anybody. I think it's a natural reaction to the proposition, but I think just to try to use time more efficiently, yes, and keep the argument in clear bounds, we should go back to the beginning. Would that be convenient to you?
My Lord, thank you very much. Can I just say one final thing by way of introduction? and that is, it's a conclusory statement, and what we say is that the context of this case, legal and factual, means that both principle and policy point in favour of recognising an actionable duty.
An actionable, sorry?
An actionable duty in false imprisonment. For what we say are, with respect, serial, unexplained, and regrettably not unusual failures in conducting reviews of continued detention. And we say that, the point here is that would maximise the incentive for compliance and recognise the gravity of the default, as Mr. Fordham says in his case, which are classic functions of the law of torts, and would be consonant with the traditional protection which the law gives executive detention. A mere declaration would do none of these things with respect. And we point out at paragraph 78 of our case why there is, we say, a pressing need for this discipline. At paragraph 78 of our case, we explain how the failure in this case was very far from an isolated aberration, because at relevant times, and owing in part to the operation of a widespread secret and lawful policy for foreign national prisoners.
But we don't get into that, do we? Because that's all been adjourned and we haven't got the judgment in abdi.
It's been stayed. You haven't got the judgment in abdi, but it may be relevant to the causation question. But it's not relevant. I'm not going into it now. It's rather complex. I won't go into it now.
I mean, I have a faint idea what it is, but I thought we had, I mean, we either have to deal with it or we mustn't deal with it.
You don't have to deal with it directly.
We can't half deal with it.
Well, I thought your point really was that a declaration is not good enough. There is something underlying this case which is of wider significance, and if the claim is to achieve its purpose, it has to have some kind of bite to it, and a compensatory element is how it's done, and that probably underlines Article 5.5 of the Convention. Anyway, let's move on, shall we?
Indeed, as Dicey says, habeas corpus and false imprisonment are the two traditional protections which the law gives. And as recognised by my Lord Hobhouse in the Evans case, this is a constitutional protection. My Lords, I was going to go to, as quickly as I can, to the statutory and policy materials. Would that assist, my Lords, my Lady? If I can then first go to the Immigration Act, and that is best found in the core volume, because it's paginated there.
It's the appendix.
So 224 onwards, is it?
I'm sorry, it's the addendum to the appendix.
Addendum, yes.
Sorry.
It's got its own tab.
Well, David hasn't got to say anything. We've got it as an addendum at the end of the appendix.
Sorry, in Appendix 1.
Yes, I've got it. It's all right.
Appendix 1 at page...
It's
224.
224 is a corrupt version
Sorry, which bit?
of the Act.
Which one would you like, sir?
Could you please go to the tab? There's a separate tab in the core volume.
No, some of us don't use the core volume. So you have to give us the page number in the appendix.
Well, it's after 324.
Yes.
Indeed, my Lord, yes.
Oh, well, I don't have
Yes,
it.
well, I don't either. I think I keep my core volume upstairs so that I can look at it over lunch. Anyway, let's waste too much time on that. You can explain things as you go along.
You also have the Act in the Authorities, Volume 1, Tab 2. I had initially marked it up there.
That's not a corrupt version. This is a
No.
reliable version.
It's not paginated. Mr. Fordham pointed out that the core volume was paginated, so we thought that would be easier.
Doesn't matter as long as we know what.
My Lords, my Lady, can I first of all go directly to Section 3, General Provisions for Regulation and Control. Section 3.5 sets out liability for deportation. A person who isn't a British citizen is liable to deportation from the UK if the Secretary of State deems his deportation to be conducive to the public good. That's the power relied on here. There are other provisions in B and 3.6. That's court-recommended deportation. Then, my Lords, very briefly, section 4, administration of control. This is relevant to a point we'll develop in due course. Immigration officers to give leave to enter, Secretary of State to vary leave, Schedule 2 to have effect, with respect to 4.2d, the detention of persons pending examination or removal. Section 5, Section 5.1, where a person is under Section 3.5 or 6 liable to deportation and subject to the following provisions, the Secretary of State may make a deportation order against him. Then 5.5, provisions of Schedule 3 have effect. Then, my Lords, page 83 for those in my Lords in the core volume. This is Schedule 2, Part 1. Immigration officers, for the purposes of this Act, shall be appointed. In Olada Hinde, the House of Lords rejected the argument that they were independent holders of statutory office rather than Carltona officials, as my Lords, my lady will well know. 1.3 is important. In the exercise of their functions under this Act, immigration officers shall act in accordance with such instructions, not inconsistent with the immigration rules as may be given them by the Secretary of State. And then various powers are set out in paragraph 2, the most significant of which is paragraph 8, Schedule 2, page 88 in the paginated version.
Paragraph 8 of what?
Paragraph 8, Schedule 2.
Schedule 2, yes. Yes.
And this is important because it triggers detention power. Immigration officers can give removal directions. That's 8.1c. In respect to people they refuse leave to enter, they can do that same thing for illegal entrance. Paragraph 9.
So where's the source of the power to give immigration?
Well, it's in the schedule.
For deportees?
No.
Page.
That's in Schedule 3. We're in Schedule 2.
Schedule 2.
And
8.1.
removal directions 8.1c.
Yes, here we are.
8.1c.
8.1c. And then paragraph 9.
Same thing for illegal entrance.
Sorry, which were in 8.1, sorry, which 8.1c?
My Lord, yes.
And that begins, give those owners or agents directions.
Directions, yeah.
Yes.
And paragraph 9 provides for the same power in respect of illegal entrance.
That's 9.1.
Yes, and the reason that's important is because it triggers the detention power
Yes.
in the immigration officer, which my Lords will see from the next page at 91. Paragraph 16.2. If there are reasonable grounds for suspecting that a person is someone in respect of whom directions may be given, under any of the paragraphs 8 to 10a, that person may be detained under the authority of an immigration officer. So it's the same structure, because we haven't come to the relevant section yet, but it's the same structure, may be detained under the authority of the immigration officer pending a decision to give directions or removal. Then over the page, I have it at 92, page 92 in the appendix.
Or just give us the paragraph now, because we're not...
17.1, sorry.
17.1.
Yes. A person liable to be detained under para 16 above may be arrested without warrant by a constable or an immigration officer. This is applied to deportation detention. Paragraph 18. 18.3, any person detained under paragraph 16 may be taken in the custody of a constable of any person acting on the authority of an immigration officer to and from any place, etc. And then this is the provision which Mr. Tam relies on, 18.4. A person shall be deemed to be in legal custody at any time when he is detained under paragraph 16 or is being removed in pursuance of subparagraph 3 above. And that paragraph, again, is applied to Schedule 3 powers. For my lords, my ladies, note, by Schedule 3, paragraph 2.4.
Well, presumably you're coming on to Schedule 3, aren't you?
Yes. My lords, my ladies, paragraph 21 provides for temporary release. 22 provides for bail. Bail is applied, again, to Schedule 3 powers. Then, my lords and my lady, at last, Schedule 3, page 119.
Here.
In Schedule 3, paragraph 2 is a critical provision. 2.1 provides for deportation, for detention where there has been a court recommendation. That's under section 3.6 and section 6 of the Act. And then critically 2.2, I'm at page 120, where notice has been given to a person in accordance with regulations of a decision to make a deportation order against him, and he's not detained in pursuance of the sentence of order of a court. And these are the critical words. He may be detained under the authority of the Secretary of State pending the making of the deportation order. So that's before the order is made. After the order is made, subparagraph 3 governs the position. Whereas where a deportation order is in force against any person, again, same terminology, he may be detained under the authority of the Secretary of State pending his removal or departure from the United Kingdom, etc.
And we're concerned with both of those paragraphs in this case because the deportation order was made, I think, in August 2007, some months before the date in January.
August 2007.
My lord's exactly right, 24th of August 2007.
Yeah.
My lords, I'm not going to go to any other primary legislation, but simply give you some references. There were going to be automatic bail hearings for people, all those in immigration detention, provided for by Section 44 of the 99 Act. You have that at 1.5, Volume 1, Tab 5. That was repealed by Section 68(6)(c) of the 2002 Act on the 10th of February 2003, without ever having been brought into force. That would plainly have raised issues under the Fire Brigades Union principle. But there it is. There are also detention provisions in the 2002 Act. You have the 2002 Act at 1.8, Volume 1, Tab 8. Section 62 gives the Secretary of State power to detain...
Which Act?
The 2002 Act, the Nationality and Immigration Asylum Act, 2002. Section 62 gives the Secretary power to detain in certain Schedule 2 cases. He is also given detention powers under the United Kingdom Borders Act, 2007. You have that at 110, Volume 1, Tab 10, Section 36. That confers powers to detain with respect to those facing automatic deportation. A new concept, which we needn't trouble ourselves with here. That's all I'm going to say.
Could I just
Yes.
ask, Mr. Hussein, you mentioned that there were various provisions of Schedule 2 that were applied to Schedule 3 situations.
Yes.
Am I right in thinking that the relevant paragraphs of Schedule 3 applying bits of Schedule 2 are paragraphs 2.4 and 2.4a?
There's also, from memory, 3, because that applies the bail provisions that you have in Schedule 2.
So that's paragraph 3, not paragraph 2.3.
Paragraph 3, exactly.
Yeah.
Exactly.
Yeah, thank you.
But exactly, it's 2.
Because that's the convenient way of looking at it.
I'm
Look
sorry,
at the
Madam.
one that does the
I'm sorry, my lord.
applying.
I'm sorry.
And then you can go back and check through.
Sorry.
Thank you.
Can I then show you the policy?
Yes.
And we have that at 287 of the appendix. My lords, my lady, my learned friend Mr. Tam and I agreed that this is a document which my lords, my lady can safely work off as governing the position during the period of the appellant's detention. In fact, there were certain other policy documents in circulation, but we are agreed that they make no material difference whatsoever to the key provisions.
Now, can we just trace exactly what this is? According to the index at the beginning, this is the Operational Enforcement Manual, Chapter 38. Is that
Exactly right, madam.
And do we have a date attached to it?
This was downloaded in November 07 by Mr. Goodman. And this was the version before the Court of Appeal. But we understand the manual to have been in existence since 2001.
So we can take this, chapter 38 of the OEM, as the policy that has ruled from 2001 throughout the period with which we are concerned, can we?
Throughout the detention of the appellant,
Yes, so
from March 06 to June 08.
It's obviously been revised because one sees references to 2003 and so on,
yeah,
2006.
and
Yes,
it's updated in February 2006, so we're very close to the critical date, which is the 8th of March 2006.
Yes, but
So we can take it as
the OEM, the manual itself, has been in existence since 2001, subject to change. This document, we are agreed at the bar, is a safe means of proceeding for the policy which governed the 06-08 period, the March 06, June 08 period.
Is Mr. Tam concurring in that? I'm not quite sure.
Can I just explain what we have done? We were asked at quite a late stage, don't make a complaint about that, quite a late stage for any other versions of the OEM which were in force during the period of SK's detention. We dug them out. I think our current count is about 10. We've got copies of them, but we're trying not to burden the court with them. We have done what work we can on trying to find out what changes were made from version to version. And in general, they've been trivial. They've been formatting changes, changes to the names of departments, and so on. We haven't spotted anything that's of any materiality to the issues in this case, and that is why we concur. Subject to finding out anything dramatic overnight, we concur with my learned friend Mr. Hussein that it's safe for the court to proceed on the basis of the document that's in the bundles.
Thank you very much. Thank you.
So 287, my lords and my lady. You've seen the first paragraph, presumption in favour of temporary admission or release. Towards the bottom of the page, to be lawful, detention must not only be based on one of the statutory powers and accord with the limitations implied by domestic and Strasbourg law, but must also accord with this stated policy. Over the page, first line, detention must be used sparingly for the shortest period necessary. And then the heading in the middle of the page, 38.1.1, implied limitations on the statutory powers to detain. And the final sentence below that, detention must also be in accordance with the government's stated policy on the use of detention.
And that stated policy is this piece of paper, is it?
Yes. And then, my Lord, 290...
Hussein, is your position that even if it were not otherwise so, by saying that it must accord with this stated policy in order to be lawful, that has that effect?
No.
No, it's not.
No, we say that the executive can't make law. We accept that. This is a policy. But what this tells us is, first of all, that the officials of the Secretary of State regard it in very serious terms. They regard it as a legal necessity. And that it, as a policy rather than as legislation, it can be departed from for good reason. But the strength of the language that we see indicates that the margin for departing from it is very narrow, first of all. And secondly, in this case, nobody has ever suggested that there was good reason to depart from it. Mr. Tam accepts that the Secretary of State's officers were under a public law obligation to comply with this policy. But we don't say that policy is law. It plainly isn't. That's constitutionally subversive. But the strength of the language is relevant to the issue of whether these are instructions or not.
Supposing that sentence weren't there, would it make any difference? Supposing that sentence weren't there, that last bit, but must also accord with this stated policy, would it make any difference to your argument?
As a matter of strict principle, it wouldn't. Because...
Does that mean as a matter of law it wouldn't?
As a matter of law. Because we accept that the courts determine what is law.
I mean, that sentence doesn't seem to me to add to be any stronger than the one we looked at on the first page.
That's right.
It's the one I was looking at,
Yes.
the one on the first page.
Yes, I mean, it's just repeated at page 288, really.
Yeah. But it's an indication of how seriously this document is to be taken, we would say. My Lords, at 290, and it also indicates that there's no, were the courts to, were this court to accept our submissions?
To do what?
Were the courts to accept our submissions, it would, there would be no administrative upheaval in the department. This is not a case like the ZT Kosovo case, where my Lord Hope and the minority considered that the ruling of the majority would cause administrative chaos in the department because of the way the fresh claim rules were working. Mr. Tam's client considers this to have legal force. But page 290, at the bottom of the paragraph, the power to detain a person who is subject to deportation order, detention in these circumstances must, underlined, be authorised at senior caseworker level in the CCD. Then the next page, 38.3.4, once detention has been authorised, it must be kept under close review to ensure that it continues to be justified. And then various factors to be taken into account. 292, the last 4 bullets against detention, various matters set out there, torture history, mental health. And then, my Lord's 296, 38.5.2, authority to detain persons subject to deportation action. The decision as to whether a person subject to deportation should be detained is taken at senior casework level in CCD, that is a criminal casework directorate. 38.5.3, we point to this for illustrative purposes. Detention in the following circumstances must be authorised by an officer of at least the following ranks. And we see the bullets do not draw a distinction between the immigration service and the department generally. An inspector is a member of the immigration service, he's an immigration officer. The SCO, senior executive officer, is a member of the department. The reason why I'm raising this is because of the paragraph 1.3 point, instructions to immigration officers. And then, my Lords, 38.6.1, risk assessment. This is an example of a policy requirement which goes to conditions or location of detention. So risk assessment must be performed, and that determines the location. So if you recall, I said a line had to be drawn. Not all policy requirements, if they're breached, sound in unlawful detention. This is an example. It's an analogue of the Munjaz Hague kind. And then, my Lords, 299, 38.6.2, authority to detain. This must be, the third line must be attached to the form and served by the immigration officer. Again, the immigration officer involved in the detention here. And then the middle of the page, something upon which Mr. Tan places reliance, that the form is issued once and only once for any continuous period of detention.
Where is that?
In the middle of the page, 299. The form, this is the authority for detention.
Oh, yes, I'm sorry. The next paragraph.
I'm sorry, yes. Form IS 91 is issued once and only once for any continuous period of detention. The exception is where there's an alteration in risk factors and there's a different location. Over the page 300, reasons for detention, reasons need to be given. And then, my Lords, my Lady, 303, detention reviews. Initial detention must be authorised at CIOHO or Inspector SEO. Continued detention in all cases of persons in sole detention under Immigration Act powers must be subject to administrative review at regular intervals. Robust and formally documented consideration should be given. Then, skipping a paragraph, a formal and documented review should be made after 24 hours by an inspector and so forth. And then Mod Q, and that is management of detainees cases unit, I think.
Management of detainees cases unit, I suppose.
Management of detained cases unit. Detained cases unit. Will request an application for long-term detention at day 20 prior to the inspector 28-day review. And then there's an asterisk which you pick up over the page. The bottom of the page, 304, such a review can be conducted early or with authorization by a CIO on the inspector's behalf. The CIO must apprise the inspector of the outcome of any such reviews undertaken on his behalf as soon as possible, as the authority the authority for continued detention still rests with the inspector. And for obvious reasons, we underscore those words. Authority for continued detention rests with the inspector. And going back to the text, detainees who've been recommended for deportation, who've been considered for deportation, must be referred to a senior caseworker in CCD to authorise continued detention.
Whereabouts are
We're
we?
back on 303.
What I was doing, my lord, is I was reading initially from 303, bottom paragraph.
Yes, I've got it.
If you see an asterisk after the third word on the second line,
Yes,
day,
yeah.
one goes over the page to pick that up. At the bottom of 304,
Well, before you get to the bottom, at the top of the page, the way those sentences are worded seem to be narrative rather than instruction. It just says the EO reviews and assistant director reviews, BIA directors review,
yes, but
and reviews are conducted. That's a description of the system.
yes, but it's prefaced and conditioned by the imperative must in 338.8. The third line must be subject to administrative review at regular intervals. You have the same thing at 291. At 38.3.4, once detention has been authorised, it must be kept under review. And then Mr. Fordham reminds me that after the asterisk, on 303, you have this. Detainees who have been recommended or been considered for deportation must be referred to a senior caseworker to authorise continued detention. And then at 304, second paragraph, and something Mr. Fordham may develop, as far as children are concerned, you've got special protection with the system of ministerial authorisation for children beyond 28 days, having been announced in December 2003. So this is a serious business, my lords, my lady. And that is picked up on, the children case, picked up on at 308, 309. Detained children, bottom of the page, detained children are subject to enhanced detention reviews. MODCU will also seek weekly authorisation to continue detention from the Minister. That is what they must do. You read this document in context, it's very clear with respect to this. Mr. Fordham, thank you. Indicates 308, second paragraph, you've got the must.
What, the entire family business?
Under family, yes.
And authorised again.
Must be authorised.
Can I, I'm sorry to, I'm just thinking, are there situations where you can have a breach of Article 5 but not, which doesn't equiparate, that terrible word, which isn't mirrored by a domestic law wrongful imprisonment?
Yes. There's a Wasink case, which we cite in our case, where what you have is a person who's detained, and the Dutch procedure required a registrar to take a note of the proceedings in court, something completely remote from causing detention. The European Court finds, in fact, the Dutch government conceded a breach of Article 5.1, because the deprivation of liberty was not pursuant to a procedure prescribed by law.
Quite.
That would not be false imprisonment.
Quite.
So you can.
Are there any other sort of examples that spring readily to mind?
Well, there's an interesting debate about whether or not a confinement or the complete deprivation of liberty rather than a deprivation of complete liberty, which you have in the Hague case, which is a test for false imprisonment, whether or not that is the same thing as a deprivation of liberty under Article 5, in particular given the recent Gillen's decision by the Strasbourg court. You can also, as far as conditions are concerned, I think my Lord said in the Walker case that Article 5 is not concerned with conditions. We respectfully, with great respect, take issue with that, because there's a Grand Chamber authority which indicates that conditions are relevant to the Article 5 question. You've got to have detention in appropriate conditions. Sardi was a case about Oakington detention for administrative convenience, but the conditions were fairly relaxed in relative terms. Okay. So that also would not sound in false imprisonment, see Hague, Monjars, etc.
Does that go beyond the fact that the conditions of the imprisonment have to be appropriate to the Article 5.1 ground? So that if you're detaining somebody because they're of unsound mind, yes, you've got to be detaining them in a psychiatric hospital. If you're detaining somebody as a child, as a juvenile for educational supervision or whatever it says, that thing, it's got to be in a suitable educational or anyway training establishment. Does it go any further than that? That's Ashingdale, isn't it?
As far as we're aware, no.
No, that's what I thought. Exactly right. Yes, it's got to link into the ground. But once you've got the link with the ground, and subject to Articles 3 and 8,
yes,
Article 5 is not concerned with.
There's a price case.
Yes.
I can't think of any other cases at the moment.
I mean, all I was thinking, I mean, this prescribed by law, which is all, I mean, very much emphasised under Article 5. I'm not sure if we have quite the same sort of emphasis on it when we're deciding on whether somebody's been common law or wrongly and falsely imprisoned.
What one's got to look at is whether or not the defect, the flaw, was sufficiently closely linked to the decision to detain. We say that's the touchstone.
Under domestic law?
In domestic law, yes.
Are you looking for what the duty entails? I mean, the detention is coupled with duties. Is that how it works? And you look to the manual to see what the duties are, or and perhaps you're coming to this anyway. You look at the detention centre rules to see what they provide.
The rules materially provide for reasons to be given and for medical examinations to be done. But both those rules and provisions have been looked at. The way we would put it is that the question is whether the lawful authority for the detention has been vitiated. And so, to take the example in the policy itself, if you had an error as to risk assessment and somebody was detained in the wrong place, he was detained in a police station when he could have been detained in a removal centre, or he was detained in prison when he could have been detained in a removal centre. And that was fundamentally flawed, that risk assessment. you could even have a bad faith case. That wouldn't sound in fault imprisonment. It sounded misfeasance in public office. But it wouldn't be fault imprisonment, because the error doesn't vitiate the lawful authority. It doesn't bear upon the decision to detain. It simply goes to the conditions of detention. Interestingly, the Australian courts don't follow Hague. Hague case, and they say that conditions of detention, if they're sufficiently bad, can give rise to a claim of false imprisonment. And I think the Court of Appeal, in the case called Middleweek, before it was overruled by Hague, had come to that conclusion as well.
Yes, I remember that one. But the greater difficulty, this distinction between conditions and the decision to detain is maybe difficult to draw, but it's an easy one to understand.
Yes.
The greater difficulty is between procedural flaws
Yes.
leading up to the decision to
Yes.
detain
Yes.
or to continue detention,
Yes.
some of which may vitiate and some of which may not.
Yes.
I'm not going back to the context of mental health, with which
Yes.
I'm familiar. Some procedural flaws in the decision to section somebody under the Mental Health Act will make the detention unlawful, some won't.
Yes.
And these are statutory provisions we're talking about.
Indeed.
Not even policies, but
Yes.
they're statutory provisions.
Yes.
And of course, the trick is to know which is which,
Well,
which we don't in lots of circumstances.
Yes, but in this context, we do, because Mr. Tan does not challenge Roberts. And what we get from Roberts is that a review does go to that question. Whatever else may or may not go to it, a review does. Roberts is not about the fact that the requirement that was breached was in a statute. It's not about that at all. And with respect, the Court of Appeal got it wrong when they focused on that issue. Because you could have had a statutory requirement that Mr. Roberts got the morning paper of his choice and a cup of coffee. You could have had that. You could have had that he would be entitled to see a solicitor. That's the Cullen case. Breach of those conditions, even if they were statutory conditions, and the Cullen case concerned a statutory condition, would not found false imprisonment because it simply got nothing to do with the decision to detain.
Well, the Court of Appeal really saying you've got to have both. It's got to be a requirement to review, and it's got to be a statutory one at that. I mean,
how does I wonder whether we could look at in that context at page 266, because this is where we find the order, the regulations, or the detention centre rules, I think they're called, and here we got paragraph 9.1, which I think is the relevant paragraph from your point of view, which says every detained person will be provided by the Secretary of State with written reasons for his detention at the time of his initial detention and thereafter monthly.
Yes.
Now, I mean, what is this? I mean, supposing he doesn't get written reasons, but nevertheless a review is conducted, just simply paperwork doesn't follow, keep pace with what's actually going on. Is that, does that vitiate or not? Or do you read into this what you find in the manual, that actually the written reasons are preceded by a review, which is looking at the substance of the thing, and it's not just paperwork? How does it fit together?
Before I answer my Lord's question, can I just answer the question Lord Brown put to me a minute ago, or the query he raised, which was that it has to be statute and the review. Well, that begs a pretty fundamental question about the status of a public law error and the doctrine of ultra vires. Why does it have to be in a statute? An executive act which is flawed is a nullity, and ultra vires the statutory powers. That's the orthodox theory of judicial review. why we would rhetorically ask, should it make all the difference in the world that you have a condition in a statute as opposed to a condition supplied by the common law, particularly when we have Lord Diplock in Holgate Mohammed saying that even when the statutory condition precedents are met for an arrest under the predecessor of section 24(6) of PACE, even when you've got statutory condition precedents, there is still a discretion, and that's got to be exercised reasonably. And if it's not, there is a claim in tort. Holgate Mohammed was a tort claim. It was a false imprisonment claim. And the issue was not, had the officer taken leave of his senses and acted perversely, but the far more prosaic one of whether or not he'd taken an irrelevant consideration into account by thinking that if he took the individual to the police station rather than question her at her home, she might confess to the crime of which he had reasonable grounds for suspecting her of having committed. And Lord Diplock found that that wasn't an irrelevant consideration. The trial judge had found it was. It was very clear that had he found it was an irrelevant consideration, she would have had a claim. And that's common law. That's a public law error, vitiating the authority for detention. So we say Roberts, the interesting thing about Roberts with respect is not that it concerns a statutory requirement for a review, but that it concerns a requirement for a review.
I mean, I'm a bit...
Plange, my lord, I'm sorry.
I'm sorry,
It's all right. I can wait for a moment if you'd like to complete the answer, but at some point I would like to...
Yes.
Because the advantage you have, I would have thought at first sight, is that you actually have a provision
Yes.
in the rules.
Yes.
And then the question is, well, having got that, do you then expand that by reference to the manual? And so we've got actually more than just, as it were, a common law rule which is being applied. We've got a structure which has been laid down, yes, which officials are supposed to comply with. But anyway,
yes,
please do complete it.
There's also a paragraph 1.3 point, which is Mr. Fordham's point in his intervention, which I'll come on to in a minute, which also gives you a statutory link. Yes. There's a statutory duty to follow instructions. Never mind a common law duty, statutory duty, yes, to follow instructions.
Well, in all the old cases, the Hardiel Singh cases, the court says, right, this chap's been detained longer than he should be, yes, he must be released. Necessarily carry with them the proposition, well, there's been a failure of some of the public law duty because they have wrongly detained him, but nobody's ever suggested hitherto that that had given rise to a damages claim for false imprisonment in respect of earlier detention. At least I've never heard of that.
My lord, it's, with respect, it's very common. There are many cases where if somebody is detained incompatibly with Hardiel Singh principles...
That gives rise to a damages claim for wrongful imprisonment.
My lord, yes, it's Mr. Tam's case. That's Mr. Tam's case. Because otherwise what you've got is a disjuncture between public law and lawful detention and private law. And that offends against Dicey, it offends against Entick and Carrington, which I think my Lord Hope called, in the Jackson case, the central organising feature of our Constitution. The executive is subject to the ordinary law. Entick and Carrington is a private law case in trespass. If something is Hardiel Singh incompatible, you recover for it.
The successful Hardiel Singh claim, you say, automatically carries with it a right to damages.
Automatically, as night follows day. And it is inconsistent with absolutely fundamental tenets of our Constitution for that not to be the case.
Yes, I see.
again, I think it's Lord Hobhouse in the Evans case at page 43F. He says that the tort is, in addition to habeas corpus, is a constitutional protection, constitutional safeguard of the right to liberty against the executive.
Could you just mention the name of the case again, the paragraph?
It's Evans. It's Evans number 2.
Evans number 2, yeah.
It's the case about calculation of release dates.
Oh, well, I mean, Evans number 2, I mean, you know, once you've got the release date wrong, I mean, there it is. You've detained somebody and there was absolutely no authority whatever to have detained him during that period. That's what Evans number 2 decides.
Evans number 2 is, if I may say so, a far more difficult case than this one. Because Evans number 2, you've got two competing principles. The first principle is that the governor is entirely blameless. Because he gets an order from the criminal court saying 2 years detention, and he miscalculates it because the governing case at the time is Gaffney. And I think my lord was in the Norton case, which
I don't want to be reminded of that line of cases, thank you very much.
I think in Norton my lord expressed doubt about the correctness of Gaffney, and then that doubt crystallised in the Evans case itself, Evans number 1, where Lord Bingham held that the calculation method was wrong. And so Mrs. Evans was detained for 59 days longer than she should have been. But the prisoner was, the governor was completely blameless. He was following the law, although he wasn't in the four corners of the court order, as my Lord Hope put it. Because the court order simply says detained for 2 years, if I remember that correctly. And the responsibility, the fundamental point that was the responsibility for calculating that how long she should spend in prison, the responsibility was that of the governor. But he was entirely blameless. So the issue was, do you visit him with an award for damages, or do you vindicate Mrs. Evans' 59 days detention? And the right to liberty won out. It's very clear from the analysis of the speeches of Lord Steyne and my Lord Hope, if I may say so, that is what was going on. Lord Hobhouse found the case much easier. He thought...
What are the two competing...
The two competing considerations was, first of all, the governor was completely blameless.
Yeah, so.
And secondly, a person had been unlawfully detained.
I mean, with respect, I mean, the competing is that the governor really had no option but to detain the chap for as long as the legal authorities then governing the position dictated.
Yes, he was bound to follow the binding ruling of the courts.
Right.
Is this saying anything other than that the tort is a strict liability tort?
It's... Well, it's saying a number of things. It's saying, certainly, my lord, that's one thing it's saying. Another more nuanced thing it's saying is that the defence of lawful justification will be the subject of rigorous application. Those were my Lord Hope's words. The third thing that needn't concern us, but I'd make forensic play out of it, if I may. Evans is a quasi-second actor situation, where you've got an executive actor implementing a court order, and it gives rise to difficult questions of legal policy and principle to do with the declaratory theory of common law and its progeny, the doctrine of retrospectivity. And that is a subject upon which my Lord Roger has offered reflections, and one might say that time is very strange indeed in that context. Because what happens is that when Evans comes along, that obviously retrospectively overrules. So you've got those sorts of problems, the sorts of problems that my lords had 2 weeks ago in the UN sanctions case. But none of that we have here at all. You've got an executive first actor situation. I'm sorry, I may have gone off.
I suppose it's worthwhile pointing out, apropos this problem about, is there an exact comparison between your right to be let out,
Yes.
or the fact that your detention is unlawful, and your right to damages?
Yes.
And there will be situations where there isn't. because there is something exempting the detainer from liability,
Yes.
even though the detainee has to be let out. And again, I go back to the Mental Health
Yes.
Act, where it may be possible for the hospital to act upon what looks like a good enough document.
Yes.
And they are protected if they do that.
Yes.
But that doesn't mean to say that if the document has been wrongly completed and is not actually duly completed in accordance with the Act's requirements, the person doesn't have to be let out. So there are circumstances, but those circumstances are those where the statute expressly says.
Well, that's one way of looking at it. My lady has in mind perhaps the SC case. SC,
I have SC exactly in mind.
SC in London. In SC, it's a very interesting case because exactly that happened. There was an error made by the social worker as
Well,
to...
it was more than an error. She
knew.
knew perfectly well the nearest relative objected, yes.
Yes, she knew. But the way the statute was framed, I think it's section 6.3 of the 1983 Act,
Yes.
that protected the hospital because it was sufficient that the committal appeared valid. I think in another case, Lord Justice Laws had considered that meant that her detention wasn't lawful.
Yes, so that was
And
overruled.
Lord Bingham overruled that.
That's right.
In SC, because he said the fact that the hospital may have a defence does not mean that her detention was lawful. Quite the contrary. If the conditions imposed by the law were not discharged, then her detention was unlawful. The question of whether or not the hospital would be liable in damages was left open. But very interestingly, what the case didn't consider was what would have happened if the first actor was sued, if the social worker was sued. Now, she wasn't doing the detaining, but she was setting in motion a series of events, the inevitable consequence of which would have been that the plaintiff was detained. And she would have been liable. She would have had no defence at all.
Well, except Section 139. Sorry, I don't want to have a private conversation with you about the Mental Health Act, but some of these questions arise in that context as well, and they're very important.
Yes, but there's got to be a statutory block.
That was the point I was putting to you, that
Yes.
you would start from the assumption that there was congruence between the unlawfulness of the detention
Yes.
and the right to damages of the person unlawfully detained, save in those situations where special protection was given to people acting on the faith of apparently valid documents or whatever. That was the point I was trying to put to you.
Yes, my lady, yes. And we say that in general, the executive first actor is not insulated in the way that a court is, in the way that a bylaw is. That's the Percy and Hall situation, which my Lord Brown will recall. So you've got a constable arresting on the strength of a bylaw, which is subsequently declared to be ultra vires, and the constable has a defence because there is a public interest in the legislation being implemented. That decision, in fact, has been criticised by certain academics, but we don't need to go there because we are concerned with an executive first actor. And
Well, can I
I'm
put
sorry.
my question again so that I can quite see how this all builds
I'm
up?
so
I mean,
sorry.
you've reminded me of Evans. It's a tort of strict liability. It wasn't a defence for the prison governor to say, well, I did what I thought was right.
Yes.
You look to see what the underlying position is, and in fact, what he was doing was unlawful according to the declared law. But here we've got...
I'm sorry, but as my lady says, there is a congruence. Evans displays a baseline principle
Yes.
of congruence between unlawful detention and recovery.
That's right.
I'm sorry to interrupt.
But in this case,
Yes.
I just want to follow how it's built up. I mean, we've got the initial authorization, but then we've got the rule and then we got the manual. And you're putting all these things together, are you? And
Yes. I'll come on to Rule 9, if I may. This is not a reasons case. This is a review failure case. And
yes.
And that is...
So by saying not a reasons case, you're saying on its own a failure to give written reasons is not enough for you, is that?
No, I'm not saying that. I'm saying that what we have complained about is the failure to review, because we say the review is the decision whether or not to continue to detain.
So when there isn't a review, it's nonetheless a decision, is it?
Well, if you haven't reviewed, then you haven't exercised your discretion, and that is a classic public law error. The review is the exercise of the discretion to continue to detain.
And that's true even of the very first review within 24 hours, is it?
Yes. That's what the policy says, which has to be followed. There are many studies that have been done about the deleterious effects on mental health of people in open-ended detention. What if someone's missed?
Yeah.
This serves a very important function. So our complaint in this case has been about the failure to conduct reviews, because we say the review is so closely linked, and in fact is the decision to continue to detain. The issue of whether or not...
So when you don't have a review, the detention it then becomes unlawful, is that right?
Yes.
But nonetheless, when you do have a review,
Yes.
it becomes lawful again.
Yes.
And you say continues. I mean, the original authority, or how does it work? I mean,
The way
what's the
it works,
theory?
the theory is, there are two ways of looking at it. Either the authority is temporally limited. The initial authority is limited until the review. It's the review which then authorises continued detention. So if you haven't got the review, which is required by the policy, then you don't have lawful justification. And then when you do get it, when you do get your review, you have lawful justification. As a matter of strict theory, the individual would be entitled to be released. In practice, it wouldn't happen, because if he moved the court, what would happen is that minds would be focused and there would be a review, which is what happened in this case.
I thought you were saying that, to take Lord Rogers' example, put it on figures, that if there was a failure to review after 7 days, there would be a breach of,
Yes.
of the system,
Yes.
which would give rise to damages.
Yes.
And that right to damages would remain, even although on the 14th day, when a review did take place, it was decided he was properly detained.
Yeah, you'd be entitled to damages for the
7 days.
For the 7 days, yes. I'm
I
not
thought
saying
you said that, and you could go through the entire history and find gaps,
Yes.
which would be filled in that way. I thought that was what your case was.
Yeah, that is our case, and that is the
Mr.
analysis.
Justice Mumby found.
Mr. Justice Mumby and Lord Justice Clark in Roberts.
Yes.
But theoretically, one way of looking at it is to say that the authority is temporally limited and needs renewal. The other way of looking at it is to say
You mean by that it can continue, it can be revived? I mean,
yes,
because it runs until the person is deported or whatever, or to the
Yes.
decision. I mean, how does it work? I'm just trying to understand
It's
how it works. So
it's revived because this was an issue in the Roberts case, because the question for the court there was whether or not, once the second review had occurred in Roberts, whether that was a good review, or whether Roberts was entitled to claim for the entirety of his detention after the late first review. There was another review in Roberts, and the question was, did he recover for 2 hours, 20 minutes, or for however many hours, 13 or 14 hours? And Lord Justice Clark regarded the second review as terminating the illegality, because you again had compliance with the statutory condition, even though actually what was required in the Roberts scenario was an arrest. But we don't have that problem, because there's no... All you need to initiate the detention is the authority. And if the review is seen as the authority, you can have the reinstatement, if you like, of the authority.
Sorry, I'm lost now. There's an initial authority. I mean, you're not challenging that there was an initial authority here, although what you say, it only goes for 24 hours or something, is that it? Well, I mean, the first review...
That's one way of looking at it. You can say the other way of looking at it is to say that there's a discretion. I'm sorry if I haven't made that clear.
I'm sorry, what's this discretion? I mean, what is the authority to detain here initially? Is it just an authority to detain for 24 hours, and then you need a fresh authorization in order to justify? I mean, how does it work?
You need a fresh decision. Absolutely, we say. That can be seen either as an authority, a fresh authority, or it can be seen as the exercise, the necessary exercise of a discretion under the initial authority to continue to detain. The statute says may detain under the authority of.
Pending, yes. So it's the initial minute, or the first hour, as it were, is authorised, but the period of it is indefinite. It has no termination point. It's entirely in the discretion of the Secretary of State, you say, and therefore it has to be controlled by the review process.
Exactly, Madam.
Could you show us the order, the initial order here, the authority, the IS, whatever it is?
It's at page 415.
Thank you very much.
So it'll be in the second... Yeah, second appendix part
Appendix part 2, 415. My Lords, while your Lordship's ladyship are in...
Sorry, I'm just reading that. I mean, the last bit says, authorises any time after notice has been given to him to cause him to be detained from the date of his release. How's this right?
On the face of it, it sets a termination date for the detention.
But my Lords, while we're in Appendix Part 2, can I show you what happens in the reviews? Can I first of all take you to...
So that's the one up to the deportation order. Presumably there's another one after it.
No, because the statute doesn't require there to be a fresh authority when you move from 2.2 to 2.3. There was one, but it's not...
This one says until the deportation order is made.
Three applies, sorry, paragraph
So
2.
632. 784. Mr. Tam's absolutely right. 784, third paragraph. That's a deportation order.
That's the order. Yeah, and where, is there any further?
The authorisation is in the third paragraph.
Oh, yes, there we are.
Yes, well, that's
That's
what,
it.
that's
Yes.
what the paragraph says.
Yes, but it, I would like to show you, if I may, because the issue is what is in law the authority and what is in law required by way of discretion, rather than what's the form of this
It's
document.
nice to see what actually happened, of course, Mr. Hussain.
I'm sorry?
It's nice to see what
Yes,
actually
no,
happened.
no, of course. Well, can we see what actually happens, my lord? Can we please go to 589, my lord? And this is the first detention review that occurred in the appellant's case, 10 months into his detention. And what the document, I'm sorry, starts at 587. At 587, so this is a minute of a decision to detain. It's essentially the review. At 588, you have a summary prepared by the lowest level of the officer. I think it would be the executive officer. And she suggests that detention is maintained, question mark. Do my lords, my lady, have that? The top of 589.
No, where's that?
Where is it?
Top of 589.
Yes. Question mark.
I see.
And then the bottom of the page, under the redacted name, this is another pretty appalling case.
Sorry, this is what?
This is another pretty appalling case. That's a reference to the fact that no reviews were conducted for 10 months.
This is the first review after 10 months.
Yes.
Yeah.
But at the bottom of the page, you have these words: file reviewed and continued detention authorised. My lords, page 701.
So you would say,
I'm sorry?
detention is authorised. Because in between time, you would say he's been unlawfully detained.
Yes.
So it's not so much continuing detention. It's really you're saying that this is an authority for lawful detention.
Yes.
I mean, is there another way of looking at it that actually the detention is authorised throughout, but there is, under this review process, public law obligation to consider, not so to speak, continuing detention, but authorising release.
Exactly.
Yes.
So it's actually a bit like the parole board. I mean, the parole board
Yes.
don't authorise continuing detention if they reject somebody's application to come out.
Yes.
What they do is simply refuse to exercise a power of release. Isn't that really what's going on here?
Well, indeed, it's the flip side of deciding to continue, which is the flip side of that is you decide to release.
I know, but it has very, very different implications, because the authority to detain is there throughout.
Yes.
And your challenge is to the public law duty to review.
Well, my lord, that's the second way we put it in our printed case, which is at paragraph 61 onwards. I'm sure it's not put as elegantly as my lord just put to me, but that's the second way we put it.
You say that to all the judges, Mrs.
Paragraph number again. Your case paragraph
61.
61, did you say?
61 through to 78. Now, my lords, Can I take you to, if you're in Appendix Part 2, could I take you to...
Sorry, assuming that analysis, assuming that, how does that work then, Mr.
Yeah.
How does your claim work?
The way it works is, on that analysis, the authority is good for the entire period.
Yeah.
Yeah.
There is a discretion to exercise.
Yeah.
May be detained under the authority of. That discretion is governed by public law standards and public law requirements. One of those public law requirements is that you follow policy. Mr. Tam concedes that his clients have got to do it. The policy says review. If you don't do it, you've committed a public law error. That is something which vitiates the... It means that you've not exercised your discretion lawfully, and you recover.
And you do it?
And you recover damages.
Well, who says that? Why?
Because the public law failure to exercise discretion properly means that the authority for the continued discretion, I don't mean the authority in terms of the act, but as far as the common law is concerned, the justification disappears.
What the review is going to do is to consider whether he should be released.
Yes.
Now, unless a decision to release is taken,
Yes.
the authority stands for his detention. That's the premise, right or wrong, the premise of the argument.
Yes.
Now, supposing they fail to consider whether to release the person,
Yes.
does that mean his detention becomes unlawful?
Yes, because he could have been released. It's an error which speaks directly to the question of whether or not he is to be released or is to remain detained.
I mean, it's starting to look more like a 5-4 than a 5-1 case on this hypothesis.
The reason we respectfully submit it's not is because the prison law cases, the analysis is different because the 5-1A authority is given by a court, and it is a second actor that's reviewing. That may not matter, but the court's order, provided the causal link remains between the detention and the court's order, means that 5-1 is satisfied, and as a matter of common law, detention is justified because of the statute, because of the Prison Act. But that's a court order. But in this situation, what you've got is an executive order, which the executive itself says has got to be reviewed. What's the point of the review if, other than to decide on the question of continued detention or, on the flip side, release? And, my lords, all the reviews say that. At 701...
Well, 701, we're looking at a detention review 4, which, unlike the one we were looking at before, is constructed to meet the requirements of periodic review. The earlier one was a notice of decision to detain, I think it was called. But now we're looking at the periodical system.
The early one, my lord...
That was page 587. It's headed Minute of Decision to Detain.
Yes, it's an internal minute.
Yes.
It's an internal minute. And it is in substance, the review. That's how it's been regarded by everyone. It's how Mr. Justice Mumby regarded it. I think, I would imagine that at the time that this was the practice. You see the forms undergoing slight changes. But the essential structure is there, which is that you've got a first-tier officer suggesting that detention is maintained, and then that being considered by people at increasing levels of seniority.
So what's the IS 91 that's referred to at 588?
That is the document, that's the authority to detain.
I know, where is it?
408.
Sorry?
408.
Oh, is that the one we looked at before?
Well, we looked
No.
at 415.
415, I think. Or is it not? Oh, yes, there's that's different.
I think this is the authority that's sent to the custodian.
This is sent to,
Well, the dates seem to match. I mean, 415, 9th of March 06. 588, 8th of March 06. And yes to the apparent question, IS 91 prepared. I mean, I may be talking rubbish, but that's...
At 408 is the
It's top
IS
right.
91, top right corner.
Yes.
yes.
What?
Says that, the
that's
top
right.
right-hand corner of the page.
Yeah.
Page 408 says IS 91, very top.
Oh, 408.
And again
We
at
got
page
it at
410.
Oh. So that's page 408.
And this goes to
To the custodian.
the custodian being the custodian of
Here it was the
Her Majesty's prison.
prison. The Majesty's Prison, Lincoln.
And this is to authorise the detention, it says. Right?
Yes.
Third of the way down.
Here's the date.
Detention authority.
It's not the first one. You would say this is the one after 10-month review.
No, this is dated the 8th of March.
Oh, I'm sorry, this is the initial one.
We've basically got a document dated the 8th of March, which is addressed to the person doing the detaining, and a document dated the 9th of March, which is addressed to the person being detained, pointing out that any constable has got the power to detain him.
Yes.
So those two obviously go hand in hand.
Yes.
But that's the initial
That's the
detention.
initial one. Yes.
But I'm just looking then back at 700,
Yes.
and then that says, I mean, what's this other thing? IS 151F.
Okay, that is a monthly progress report. That's the document which is at
Well, we have one at 705, actually, as an example of a one IS 151F.
We've got one at 631 as well.
My lords, we've got many. I was just trying to trace the one that matched with this date.
Well, this is probably it, isn't it? You're right, because 705 is 24th of May, 701 is 22nd of May. I don't know.
But my lords, this ties in with the point that my Lord Hope was asking me about, which is that the form IS 151F is in discharge of the Rule 9 duty to give reasons.
Right, I see, yes.
So this is an internal document. This is an internal document at 700, and then that is supposed to find its way into a document which is served onto the individual, One of the things that was happening was that document was being served on the individual and saying that your detention has been reviewed, when in fact it hadn't been properly, and that was the reference to casual mendacity.
No, I follow that,
It's
but
just as
is 705 what the chap gets after 701 has been written up?
Yes, exactly. Yes, it's 705.
So
And-
there's the reasons for his continuation, is it?
Yes. And in the middle of the page at 705, you have the sentence, your case has been reviewed.
Yeah.
The bottom, your case will continue to be reviewed on a regular basis.
Yeah.
So we're in legitimate expectation territory, even if the policy wasn't sufficient to found the expectation, even if Mr. Tan didn't agree that there was a public law obligation to follow policies in modern public law. But 701 is talking about authority to maintain detention.
Well, I see, yes.
699 is where the document begins.
Yeah.
Yes. And the middle column in the table, authorization required. The 699, my lords.
Yes, no, I absolutely follow. I mean, I suppose in one sense, the question is it properly to be construed as, regarded as, I don't know, an authority to...
Well, yes, but my lords, what we say is that this conclusively neutralises any forensic advantage that my learned friend can draw from the wording of the authorities that you've seen. If you're swayed by what's on paper, then we can point to a plethora of materials which say that authority is required. Everything in the policy says that. The policy say it, the forms say it. If you look at 732, so 731 is the same as 699.
Yeah.
732. This is one of those that didn't go off very well. But you've got the space for authority to maintain detention given, and then you've got.
Well, that's exactly the same as
Yes.
699.
Yes.
I know, no.
It's settled. There's a. And then at 855, a document beginning in 853, slightly different form. The proposal at 854, at the bottom of the page, is that you maintain detention. On 855, you have a recommendation for continued detention.
So where's the proposal?
The proposal is at the bottom of 854, maintain detention.
Sorry, 85.
854.
And then at the
Yeah.
In the middle of 855,
Yep.
a recommendation for continued detention, and at the bottom of the page, authority to maintain detention given, authority to maintain detention not given. Now, I didn't mean to concede earlier that because one of the things that this review is deciding is release, that the default position is that the individual can just remain detained. I mean, if you look at all the policy documents, you look at the forms themselves, they all speak with one voice, and they all talk about maintaining detention, not considering release, and they all talk about authority for maintaining detention.
Supposing they all said release,
Yes?
would you be arguing that that decided the case?
It's not dispositive. Of course it isn't, my lord. But I mean, well, can I engage with my lord on a question of principle in that case? Mr. Tan, in his printed case, in rather Delphic terms, accepts that the right to liberty is important. If there is a right to liberty, then the default position is that you need to authorise detention. And you need to do it on a continual basis. Because the policy statements make very clear that a review is necessary to ensure that detention remains justified and in accordance with policy. And you get that from page 291. This is the document we were looking at earlier. And that is chapter 38.3.4. So we and then can I also can I show you the current policy? You get that from the current policy, which is at volume 2, tab 15.
Two of the authorities.
Yes, volume 2, the authorities, tab 15. At 55.8. And what is said there at 55.8, I'm not going to read out material which you've already seen.
Does it make any difference from,
It's
from what we've already seen? I mean, is it significantly different?
It makes it very clear on the facing page, 55.8, at the end of the first paragraph, detention reviews are necessary in all cases to ensure that detention remains lawful and in line with stated detention policy at all times. Does my lord have that?
Yes, just before the break, isn't it?
Yes.
Uh-huh.
Now, so that's policy. I take the point my Lord Roger puts to me. But as far as the Secretary of State's officials are concerned, they think that it's necessary to continue to authorise detention. They think that the default position is release because there is a presumption in favour of release. Detention is a last resort. We saw that in the policy. And as a matter of principle, aliens, like own nationals, have the right to liberty. We saw that in the Belmarsh case. They have an equal right to liberty. You get that from Article 5. Article 5 begins with the word everyone. And this is why the situation is not like the parole board situation. Because in the parole board situation, the individual does not have the right to liberty. It's been taken away from him by an order of a competent court.
I mean, the Hardy-Singh principles require that the detention must be reasonable in all circumstances.
Yes.
I mean, why do we necessarily read this other than as saying, in order to ensure that that aspect of the Hardy-Singh approach is complied with, well, you're going to have to make sure that there are reasonable, good reasons to keep this person in detention, and that's why you need these constant reviewing processes,
Well, that's certainly one function of the review, to ensure that it remains...
Well, that's what it says, that to ensure it remains lawful and in line with stated detention policy at all times, which would involve that he's not detained for longer than is reasonable.
Well, no, the policy says that you mustn't detain if removal's imminent. That's not necessarily the same as Hardy-Singh. It says that you shouldn't detain somebody who's mentally ill. There's a very strong presumption against doing that. There's a very strong presumption against detaining torture victims. The courts have well recognised cases where breaches of policy occur, rendering detention unlawful, even though detention would be compatible with Harding Singh. It's an extra protection. And as a matter of public law, the Secretary of State's obliged to follow it. The judges below, my lord, also make it clear that there is a need for a detention review because otherwise the power of detention may no longer exist. Can I show you Lord Justice Keane at paragraph 46, please? Paragraph 46 at page 1544A, after the first sentence, the need for such regular reviews stems from the necessity for the Secretary of State to monitor changing circumstances in a given case. And then these are the words, lest his power to detain on the principle set out in Harding Singh no longer exists. And then the following sentence, my lord, even if the power still exists, he has a discretion to exercise which he must also keep under review. Then Mr. Justice Munby, my lords, at paragraph 68.
Paragraph
68, we're in appendix.
Yeah, we're in the core bundle. Appendix 1, yeah?
Core bundle, appendix 1 at page 151. Final sentence, page 151, paragraph 68. Final sentence, those reviews are fundamental to the propriety of the continuing detention. They are required in order to ensure that the continuing detention can still be justified in the light of current and perhaps changed circumstances, and they are, in my judgment, a necessary prerequisite to the continuing legality of detention. So required in order to ensure that the continuing detention can still be justified. And that must follow. It must follow unless aliens do not have the right to liberty. And no court has found that. And Mr. Tam doesn't contend for it. And on the contrary, the Lordship's House in the Belmarsh case found that they did.
I mean, I don't suppose that's a contentious proposition for a moment.
Well, if it's not, then it follows that you've got to justify detention. You can't simply do it one-off at the beginning of a period that may last years. In this case, 22 months by the time of Mr. Justice Munby's decision. And all well and good. Mr. Tam's whole case is based on the idea that the initial authority is like a court order. Never mind the fact that the Harding Singh itself is predicated on the proposition that the authority does not and cannot last until deportation takes place. So we are not, I'm sorry if I'm repeating myself, we're not in the parole board situation. We're in 5-1 territory. My lords, can I am going to come to my Lord Hope's point.
Well,
about...
in a way, Mr. Justice Munby, paragraph 68, is putting the thing together in the way that I thought you probably were. So I think this is your proposition.
That is my proposition, absolutely. We respectfully submit that Mr. Justice Munby's decision on this point was correct in all respects. I'm not at liberty to challenge his conclusions on the Harding Singh issue. but we respectfully endorse his reasoning and conclusions in every respect on the first point. We say they are consonant with fundamental principle. We say, with great respect, the Court of Appeal and Mr. Tam's submissions are inconsistent with fundamental principle. They're predicated on the proposition that public law constraints cannot supply, public law requirements cannot supply constraints to the power of detention, executive detention. As far as Article 5 is concerned, they're predicated on the proposition that statute, main statute, not even subordinate legislation, that main statute and substantive public law, Hardy will sing, that's all you have as far as law is concerned. We say, with respect, that's simply untenable. Now, I do need to make some submissions on the reasons point, because it's a difficult area. There's a House of Lords authority of Sadi, which looked at that point. And I'll do that in due course. It's a point you don't need to decide, because this is a case about review. But I will make short submissions on the Sadi issue. But can I at least give my Lords references to other policy documents which have the same theme, that a review is necessary to ensure that detention continues to be justified. You have the 1991 document at 116, and following on from that, I'm sorry, at 216. And what?
216,
Volume 2, tab 16.
Oh, sorry.
I'm so sorry, Murray. I'm so sorry.
Yes.
Volume 2, tab 16.
Yes.
So these are Immigration Service instructions dated 3rd of December 1991. Second sentence, once detention has been authorised, it should be kept under close review to ensure that it continues to be justified. And then flicking on 2 pages, at page 4, paragraph 8, at the top of the page, once authorised, detention should be reviewed by an inspector within 24 hours. Designated inspector must, of course, authorise detention in devolved authority deportation cases. But paragraph 11, I'm sorry, that I think it's talking about initial authority. I'm sorry.
Yes, it's really 11.
It's paragraph 11 I wanted you to look at. On authorising initial or continued detention, the inspector should specify the next detention review. And then 12, authority at minimum of inspector is required for children. Once authorised, detention should be reviewed by an assistant director within 24 hours. This is a document some 19 years old. At page 6 of the extract, you have the 1994 document. And this says this, just above the underlined sentence. Every 2 sentences up. Every effort should be made to reach reasonable assessments of these last factors, both at the time of the original decision and when reviews of detention are conducted. It's not sufficient on review simply to conclude that the factors which led to detention remained unchanged, and thus that continued detention should be authorised. Rather, the longer a person has been detained, particularly if it's the result of a failure in the Department of Home Office to resolve his case, the greater is the onus on us to justify continuation of detention. So it isn't sufficient to conclude that which led to detention in the past justifies it now. What's going on here? We accept that this is simply a policy document, but the underlying principle is that the individual is entitled to their liberty if continued detention can't be justified. Because otherwise, you could simply have the initial authority and assume continuity or assume no change, and that would justify continued detention. But that's not what's happening.
Why do I keep thinking of that, of the IPP cases?
But the IPP case is different in three respects, at least. It's different. This is the Walker case. It's different, firstly, because it's a court order case. The sentence is authority for the entire period of detention. Secondly, the body that had systemically erred, the Home Office, did not have power to release anyway. It was the parole board that could make the recommendation, and alone, and only the parole board that could do so. So what you had in Article 5 terms was a 5.4 issue and not a 5.1 issue. What you had in common law terms was authority for detention, just as you had it in Norkoyev, just as you had it in Dunn.
In what?
In the Norkoyev case.
And then you mentioned
there's a case called Dunn upon which Mr. Tam places reliance, which applies Norkoyev. It's a Norkoyev type situation. And so it's very different.
It depends on the context. Can authority in one context be regarded as synonymous with legality? Or should it, as you would have it in this case, should there be a recognition of two different concepts, legality and authority? And authority in this case doesn't provide a comprehensive, conclusive answer. There are two aspects to legality here. One is authority, of course, but the other is review of the justification for continued detention.
Yes. My Lord's absolutely right, because in the prison cases, in the IPP cases, in the Norkoyev kind of case, authority is coterminous with legality. It exhausts it. You've got the authority, that's it. Save in extreme circumstances where there's a complete breakdown in the parole board system, Article 5.1 is satisfied. And the common law is satisfied. There's nothing else.
Well, we've reached 1 o'clock. I think it's time to break. How are you progressing? According to the timetable, you've got another hour and a half.
Yes.
Obviously, we've been asking you a lot of questions, maybe some room for manoeuvre on the timing, but it's essentially finished today to give time for Mr. Fordham and Mr. Tam.
Yes. I'll certainly do that.
Yes, very well.
And I hope I may be able to finish in time. My Lord's questioning has, I think, enabled me to cover quite a lot of terrain that I was going to do when I was developing my 9 points.
Thank you very much. Well, we look forward to seeing you at 2 o'clock.